So, good evening, everyone. I'm Shreya, student co-convener of Center for Legal Aid Program, NUSRL Ranchi. I'm your host for today's evening. On behalf of CLAP and ProBono India, I welcome the resource person, Professor Dr. M.R.K. Prasad, members of the organizing committee, Dr. Kalpesh Kumar L. Gupta, founder ProBono India, faculty conveners of CLAP, Dr. Kaushik Bakshi and Dr. Shweta Mohan, student coordinators, and all the participants to the third day of short-term course on legal aid and allied laws. Yesterday, we had an enlightening session with Dr. Kalpesh Kumar L. Gupta on legal aid in India, issues, challenges, and legislations, shedding light on the view of judiciary on competence of legal aid councils and the quality of legal aid being given to the Section 12 beneficiaries, the practical aspects and the working of legal aid centers along with the challenges faced by them. For today's session, we have with us Professor M.R.K. Prasad. Dr. Prasad is a leading expert in clinical education in India, the first recipient of Vanderbilt Fulbright Scholarship in Clinical Legal Education. He was a member of the committee constituted by Chief Justice of India, Patron-in-Chief NALSA, for preparing guidelines for the legal services institutions, engaging legal aid services clinics set up in the law schools, colleges, and universities. Over the course of his career, he has served as principal from 2015 to 2020, Dean Faculty of Law, Goa University, and Chairman Board of Studies in Law, Goa University, and as a professor of law at the Indian Law Institute, New Delhi. He is instrumental in establishing and functionalizing community legal aid clinics set up by a law school, law college in the community. And for this initiation, VM Salgaocar College of Law received the Institutional Excellence Award 2011 from Society of Indian Law Firms and Menon Institute of Legal Advocacy and Training. We welcome Professor M.R.K. Prasad, Professor of Law, VM Salgaonkar College of Law, Goa. We welcome you, sir.
Thank you very much. Can you stop sharing the screen so I could share my screen? Okay, is that visible to you?
Yes, so it's visible.
Okay. Okay, good evening to all of you. First, let me thank Kalpesh for giving me this opportunity to speak about clinical legal education. And we have a long standing bond between us. He is young. I'm a little senior, I could say. I wouldn't say that I'm old, but we had the same passion that all the law schools should have these legal aid programs and the students should get benefit out of it. So today he asked me to speak on clinical legal education. Therefore, I may not be speaking much on legal aid because I think my colleague, Dr. Patil, has already spoken to you all how the legal aid work has done in Salgaonkars and how law colleges can adopt it. As a clinical teacher, I would have loved to have all of you in physically present and have some kind of simulations, etc. But with a limitation with the online mode. Maybe I'll ask all of you to have a pen and a book or a paper with you. Sometimes I may request you to note down something, then you can check. First, I thought, let me start with what would be the life in a law school for a student. I was told that there are 70% of them are law students and few academicians and advocates are there. So maybe I'm focusing a little more on the students. When you join either from 12th standard directly to the professional program, and I know that there would be some students who completed their graduation and then joined law. But now, 5 years course gaining momentum, most of them are choosing at the very young age. What is your life in a law school? One, that we understand that a student coming to a law school is a big jump from a 12th standard directly coming into a professional course, because the professional course expectations are different, aims are different. Till 12th standard, you must have been spoon fed. Your teachers are saying what to read, how much to read, practically dictating the notes, telling you what question, what answer should be written. And when you come to the law college, you will see that in each subject there will be 10, 15 books are available. Hardly any teacher will tell you, or give you a notes, etc. Then, therefore, in a law college, what is important for a law student is a self-motivation. How do you motivate yourself to study, be relevant in legal education and legal profession, and of course, the competing peers that you have. Then, the most fascinating thing in a college is the freedom that you get. Because till 12th standard, maybe your attendance is known to your parent, parent will come, drop you, pick you, you can't leave your school in between, etc. But that doesn't happen in law college. Law college is free for all. You come, you go, you bunk lectures. We know how we used to sit in canteens. And if you ask me, I learned more law in canteen with my teachers than in my classrooms. So that freedom you will have. And then we in the law school all of a sudden tell you apply your mind. So earlier you are reading from the textbook, whatever they say you believe you write. But when you come to the law college, we will not say that this is the law and you must follow. Then we would say this is the law, why this law has come, and how do you apply this law to a situation when your client walks into your office. So therefore, by hearting, remembering, reproducing is of a little value when you are in a law college, because you need to develop this application mind, the analysis of the application mind. Okay. Then because it is a professional college, professional course, we have certain ethical considerations, certain ethics that we need to follow when you are submitting your papers, when you are writing articles, etc. Plus, as a lawyer, what kind of ethics that you need to follow, those things we will teach. Then the another problem, of course, this is much more with the rural students, that you study till 12th standard in your local language, in your mother tongue, and all of a sudden you come to English, you grapple with the problems of language. One. Yeah, Shubham, self-motivation, I said that you need to be self-motivated in a law college, because the individual attention of the teacher for each student may not be as much as what you felt in 12th standard. That's what I mean. The freedom in a sense that there is no monitoring system in most of the colleges, where we will send your attendance to your parents and all those kind of things will not be there. So therefore it is allowed for you to bunk some classes, move around with friends, etc. So therefore there is a freedom. Then the multicultural thing, that when you are joining, when you are leaving your home, joining in law colleges in different states, etc., you have different cultures, cultural backgrounds that the students come. And the most important thing is that work without supervision. That means most of your works are without supervisions. Maybe 20% is the teacher's supervision on you. 80% is your self-supervision. That is where the law colleges differ from the normal courses. Then there are two things, that is the integrity as a student, whether it is your internal assessment, whether your internships, whether your examinations, whether your submissions, that integrity is very important. And the last and the most important, that is where the clinical legal education I am leading you to there, is the practical skills. That as a law student, learning law is of no use unless you have certain skills that you learn in the law college before joining into the profession. Anyway, I'll come a little later about the practical skills. And the last one, and the most important one, is update or obsolete. As a law student, you need to update every day what is happening in the country, whether it is socially what is happening, politically what is happening, legally what is happening, new technologies, new laws, everything that you need to update. Therefore, as a law student, once you become a lawyer, you are still lifelong a student until you retire from your profession. I think this is the same with the teachers also, it would apply that they are students. So now my question to all of you, just to think and ponder about whether we should call it as a law school or a lawyer school. When I say law school means that the obligation of the law college is only teach you law. When we say lawyer school, that in addition to teaching the law, that the student should also learn the lawyering skills. So therefore, I'm just asking you, you can quickly respond. If you think it is a law school, type 1. If you think it is a lawyer school, 2. Means what should be the law college? Whether you want the law college as a law school or a lawyer school. Okay, 1, 2, 1, 2, 2, 2, 2, 2. Yes. Looks like there is a split verdict. Okay, so now probably this is a debate in late 80s. Now there is no such debate, but just I want to see the young minds, how they are thinking about law college. We absolutely feel that it cannot be a law school, it has to be a lawyer school. That means as a law student, when you complete your law and join in the profession, you must learn certain lawyering skills. I understand that no law college can make a finished lawyer. That's not possible. You need to learn certain skills in the profession, but you need to be prepared for the lawyer's profession. Therefore, we expect that the law college should be a lawyer school, not simply a law school. That means simply teaching a theory or what the law is or what law ought to be is not enough. But how that law is applied in real sense need to be taught to the law students. So I always take, I know it is 7:15 and we will be hungry by the third slide. When you join in a law college, you look like this. That means you are just a raw material. It's a nice, soft dough. Then you attend the lectures in the law college. So the classroom teaching makes you the base, the pizza base. But then nobody want either this or this. We want this, right? So what is that I'm trying to put this picture is that if you look at this picture, this is a pizza where you can see the nice bell peppers, nice fried mushrooms and cheese and the golden crust all. So this is what the lawyer is. So when you join in a law college, learning in a law classroom makes you only a pizza base, or you are learning only a basic knowledge. So what you require is those skills, those kind of toppings that what we are talking. So therefore, as a student, you join in the law college, attend classes are not enough, that you need to learn how to be a lawyer. Now, if I look at a profession, a professional education, generally it has the three aims. One is it should make you to think. So when you join in a law college, the law college should make you to think. How does it make? The teacher provides you knowledge, then you start thinking. For example, the teacher tells you what are your fundamental rights. what contracts are void, what contracts are valid, etc. So with that, you start thinking. But knowledge is not enough because as a lawyer, you have to perform in the court. Therefore, you need skills. So the law college or any professional college, forget about law college, even any professional college must teach you the skills. If you take medicine, the knowledge of the disease, what medicines to be given is the knowledge. But how do you diagnose is the skill. Then the third one that the professional education gives the students is the attitudes. What kind of attitude as a lawyer, as a doctor, as a CA you should have. That is what we generally call as professional etiquettes, professional skills, professional values or ethics that we talk about. But I believe that legal profession is different from other professions. What is the difference that I look at as a legal profession is that the law that you are learning in the law college must make you socially relevant. That means the legal education that we are providing in law college must be socially relevant legal education. Why we want socially relevant legal education is as a lawyer, you are useless if you are not relevant to the society. See, a doctor will only treat the disease, but he will not investigate why diseases are coming. It's not his job. But as a lawyer, you cannot. Lawyer has multiple roles. So therefore, I believe that the legal education has the fourth dimension of making it socially relevant. And there are two statements that if there is one report, Carnegie report on American law schools, it came about 10 years back. They went to premier law schools and started investigating how the law is taught. See, one of the statement, it says that the law school create people who are smart without any purpose. That means a legal education in America creating smart people, smart lawyers, but they have no purpose. Similarly, we have this feeling that we have, of course, we recently celebrated Chandrayaan, that we can go to moon, but we have a trouble in crossing the road or the street to meet our neighbors. So how many of our law colleges are engaging with the community? If we don't engage with the community, then what is the purpose of the law college? Because law is for the purpose of society. So, therefore, what are we teaching in law college? Whether what we teach in law college is relevant in your legal profession. That's the base question. That is what I'm trying to talk about the gap. That we all understand that what the theory that we teach in law college, I'm not saying it is irrelevant, but it requires more. So the learning in the law school is not sufficient for the students to practice in the court because there is a gap between theory and the practice. What kind of gap that we see? We see that there is a disjunction between the law and the society. I'll give you several reasons. First one is the language. The language as a lawyers, the language as a law students and law teachers speak is English. The community doesn't speak English, right? So we learn the law in English, but the actual language that the people speak is different. And even if you are speaking, if the community can speak English, the legal language, the legal jargons are different from normal language. Therefore, one of the duty of us is that we speak in the community language. The vocabularies that we say, that we talk about so many legal jargons, people will not be in a position to understand. And if you see your 5 years or 3 years whole course curriculum makes you as a lawyer to litigate in the court. As if the justice can be only given by the court and every problem that comes to a lawyer has compulsorily go to, except one subjects, most of the time they teach in final year, the ADR, where you talk about negotiation and mediation. But most of the time we talk about litigation. That means if you have a tool of a hammer, then every problem looks like a nail and you are going to do this. You don't have other tools. If you have different tools, then the problems looks different. And this is, I no need to establish this. The law is an urban-centered focus. Law colleges are urban-based. Everything is urban-based. Even if you look at the subjects that affect the rural India, hardly except the land lost, probably nothing will be done. And the discussions in the law colleges, particularly in classrooms, are philosophical. Very philosophically, we will talk. I'll just give you an example. We say that 100 culprits may escape, one innocent should not be punished. It is very philosophical, great. But then in reality, what will happen? In reality, if one culprit is escaped, that gives a much higher impact on the society about how the law protects a person. Similarly, the values of the lawyers, values of the legal profession, values of the society may be different. See, the value of the law is that we want to have Article 21 to be strictly followed, procedure established by law must be just, fair, reasonable, but the social values are that the culprit should be punished faster. So there would be a clash, right? So therefore, what are we going to do? We understand that there is a gap. What should we do as a law students, law teachers, or lawyers? What should we do? First, we need to address this. You have a problem in voice?
So it's fine, sir.
Okay,
Yes, sir,
okay.
it's fine.
Okay, thank you. So first, let us understand: is law as an academic discourse only, or is it a profession which requires performance? As an academician, I look at only as a discourse. But in reality, it requires a performance, because as a lawyer, you have to perform after you leave the law college. Therefore, what we need to do is we need to understand the gap. What is this gap and how to bridge the gap? How to bridge the gap? That is very important. We will not able to, or how to narrow the gap, I would say narrow the gap. As a law colleges, we will never able to convert you into a complete lawyer and send you. Not possible. No professional course is possible to do that. Even as an MBBS, after you finish, you will go to house surgeon for 1.5 years minimum so that you become a doctor. Now, how do we understand? First thing is the academic rigor. That means what we teach in law college, entirely not used in the practice. I'm not saying that law colleges are bad. The theory that you are learned, sometimes you don't see the correlation in practice. And particularly when you study the natural law theories, the historical school, etc., how much you are going to use it in the courts. We do use, but we don't get that connection. We don't get that connection, right? How do we reconcile between what is academics and what is the professional requirements? I'm just putting a small table there. Now, if you look at most of our end-term examinations, thankfully now we have internal assessments with the different methods, luckily. But most of the colleges do have the end semester examination where higher value was given to that, requires memorizing. Whereas the profession doesn't require memorize. You can carry your piece of paper in front of the judge, you can read and explain, which you cannot do in an examination. So therefore, examination encourages memory-based, whereas the profession requires analysis. And even when we are giving the problem-based tests, even in our college, we give problem-based tests. Problem-based tests also doesn't give you the same level of analysis because our problems are unidimensional. Means if I am teaching you contract, I will give you a pure contract problem. Whereas in legal profession, a contract may be coupled with banking problem, contract may be coupled with constitutional law problem, it could be a tax problem coupled with something else. Because usually the cases that comes to your lawyers are multidimensional, not unidimensional. Then that is one of the reasons where law schools are struggling to have this interdisciplinary approach. For example, when you are talking about dowry prohibition, whether you are talking about sexual harassment, whether you are talking about 498A and all, it is not pure law. It is sociology and law. In spite of we are having BA, LLB, BCom, LLB, BSc, LLB, unfortunately, we are unable to connect those two. Because sociology is taught by a sociology teacher and maybe constitution is taught by a constitutional teacher when they don't come together and talk about untouchability. Okay. So therefore, the teaching has become compartmentalized, and what is taught, what is important in law school may not be important in profession. I'll give you an example of when you are studying the whole Negotiable Instrument Act. In your practice, what is important is 138. But that doesn't mean that the entire Negotiable Instrument Act is itself is useless. You need to have that background. What is negotiable instrument? What is check? What are the attributes, etc., etc. You need to learn, no doubt. But then there should be more emphasis on 138, where the teachers would be not focusing on that because we have limitations. The biggest limitation is that we are not practicing lawyers. We never practice. And you all know that we can't. Okay. And also we see that academic success, that means the topper of the college need not be a best lawyer. There is no such correlation generally. And I have seen some of my best lawyers today are the backbenchers who generally don't open their mouth in the classrooms. Okay. So what is this problem? The problem is that we already explained that. There are few things that I need to tell you is that the law students are not getting this practical training. It's practical training not only about your skills, but also the soft skills. For example, how do you speak to your client? How do you address your client? How do you receive your client? Even when you are going for an interview, how do you face the interview? These are the etiquettes that need to be taught in the law college. How do you write your CV? Then the community engagement. Many colleges have very less interaction with the community. Interacting with community itself is an education. Even though we give simulations in the classrooms, in simulations you don't get because what happens in simulation, you know very well that it is not going to affect the real clients. That's what I see when I conduct a simulation in contract class, asking them to enter into a contract. The students are very generously buy things and generously sell the things because they are not actually paying that money. At the end, they know that if they made a mistake, the teacher is there to correct. But in real life, when you are drafting a contract, you don't have that leverage. So therefore, simulations are great, but it will not give you the complete experience of a actual practice. So this becomes a chicken and egg problem because the law colleges are unable to cope up with proper education. Legal profession is bad. We will say that the legal profession is bad. Because of that, the law students become bad. So it's kind of a chicken and egg problem, which is first, which is. But what we forget is that legal education and legal profession are interdependent. The lawyers need to come to law colleges. Law teachers need to discuss with lawyers. So how much responsibility the law college has, the same amount of responsibility the bar is having on improving the skills of the law students. That's where the bar, even I would say the bench and the college, all three together need to require to bridge this gap. So I'll just skip this. So therefore, What are you going to do? How we are going to address, or how do you going to narrow this gap? One is that the clinical legal education, we expect to address these problems. I'm not saying that the clinical legal education is a magic wand. Okay, I saw a nice quotation somebody said, yes, the society is a lab where you need to experiment. That is where the community engagement is required. That is what the clinical legal education is all about. But according to me, clinical legal education is much more than community engagement. So it is the Russian professor who proposed this clinical legal education in law in similar lines of medicine. So the idea of the clinical education came from the medical profession. So what is it? It is a kind of an activity where the law students would learn by performing the actual or simulated task that which we would be doing as a lawyer. That means as a lawyer, what you are going to do, that you would learn in the school setup either by simulation or by doing actually. For example, in an anatomy, the professor will explain the anatomy and then they take the students to the hospital and show this. That is what we expect clinical legal education is supposed to do. Okay. So the expectations from the clinical legal education is it is going to develop the fundamental knowledge. That means the knowledge that you learn in a theoretical discussion and the knowledge that you are going to learn by doing something vastly differs. It vastly differs. The retention rate is the lowest in case of a lecture method. It is 5%. That means if I teach you 100 minutes, you retain only 5 minutes of that 100 minutes if I am doing through lecture. And we all know that the lecture method is a predominant method in law colleges. 90% and sometimes I'd say 95% is a lecture. Therefore, we need to adopt this clinical method of teaching so that the students' learning capacity would increase. And the clinical method also makes the student to improve their capacity in engaging complex issues. Generally, we will look at issues which are simple in a problem based. But in actually, if you read so many case laws, they are complex. So therefore, you are exposed to the complex issues where the student is able to judge. What are you judging? Judging the conditions of uncertainty. For example, in moot court, because the moment we say practical, everything comes into the moot. But in the moot court, any time you have seen any judgment given, does the student judge? No. So, as a lawyer, as a judge, you should able to judge the uncertainty. So that experience that you should get from clinical legal. So the clinical legal education allows you to learn from experience. So experiential learning, there is no substitute for it. Right? So, and again, when we are, say, for example, when you are taken to a legal aid or when you are going to an internship where you are actually meeting the clients, you become much more responsible there in the classroom. For example, the professional ethics, when I ask you a question, you give without any hesitation, but it is a person whom you see and that person poses that, it becomes difficult for you to judge and decide because you feel more responsible when there is a live client. So, what is the purpose of the clinical legal education? We want students to be competent. We want you to be a competent lawyer. And at the same time, you are also socially responsible. That's what the clinical legal education is supposed to aim at. That means you learn the skills, but learning the skills are for the benefit of the clients and the community. And then when this clinical legal education was first mooted, and then particularly the American law schools have taken it into a greater heights. Though India and American law schools started their clinical legal education on probably in 70s more seriously. Uh, there was a debate. The debate is whether the purpose of the clinical legal education is whether to increase the professional skills of the student or whether it should be designed for the providing the justice to the. And initially, the clinical legal education started with the second objective. That is, the law students and the law teachers shall provide legal aid to the poor. Therefore, it is the very purpose of the clinical legal education is to provide access to justice. However, over a period of time, the people realize the potential of the clinical legal education. And now we look at both. That the clinical legal education try to integrate these two objectives. One is it enhances the learning experience of legal education in the classroom. That is where your skills part comes. That means clinical legal education improve your skills. But at the same time, the clinical legal education also should encourage the students to provide service to the community. Therefore, it has two aims. The one aim already, I think previously it was discussed about legal aid and all. So I'm not going into the legal aid. I'm going to look at the first one, how it would enhance the quality of legal education. Now, I see clinical legal education as a pedagogy. Pedagogy means it's a teaching method. So whoever is into the teaching profession, who is attending this talk, look at clinical legal education as a pedagogy in a classroom teaching. Not necessarily only in a practical paper, but also all substantive laws can be taught in a clinical method. Second one is clinical legal education for skills training. That is where the practical papers come into picture. Third, clinical legal education is the experiential learning. This is where the legal aid comes. When you do community engagement, when you do clinics, when you do legal aid, you learn by experience. Okay. And the last one is clinical legal education for the purpose of community engagement. Okay, how do you engage with the community? Is through clinical legal. Now, clinical legal education is a pedagogy. Now, most of the teachers are familiar with this learning objectives. The Bloom's taxonomy, it talks about when a student attend class, the student has to undergo the 6 stages. That means when you sit in my class, I should be able to provide you knowledge. You should be able to comprehend what I taught. And you should be able to apply what I taught to a problem. And you should be able to analyze the problem and the law. Then evaluate whether this comes under within this law or this principle will apply. And then the last one is you should be able to create something new. Okay. So there are 6 stages that the students should enter. Say, for example, when I'm teaching law, when I teach Donag versus Stevens, you know the facts of the case. That means you have the knowledge. You understood the judgment. That means it is a comprehension. Then you apply this to any other product. For example, it is a beer bottle. Is the beer bottle, the fan snaps and falls on you because of the defect in the material. Whether the Donag versus Stevenson can apply to this situation. Then analyze why it is. Then evaluate what would be the impact of such law. For example, that law creates manufacturer liability. When manufacturer is liable for the defect, they has to use better material. Better material means more money. Cost. What is the cost? How that affect the general public? Then create. So these are the 6 areas that you need to undergo. Can a lecture method able to bring all these things to the students? The answer is no. Therefore, we need to adopt clinical method. Now, it's a time for you, maybe take 2 minutes and write down what skills a lawyer requires. Just think about it, write down. If you want to type in that, it's fine. What are the lawyering skills that you need to learn if you want to practice in the profession? Yes. Very nice. Analytical, critical thinking, convincing power, listening, language, negotiation skills. Now let me ask you this question. Why we are listing these skills? Yeah, you go on typing, it's fine. Why we are talking about these skills? Because the moment when we identify what the skills the lawyer required, then your teaching should be to enable those skills to the students. That means we need to mold our teaching to provide these skills. There was only one attempt was made in America by the McRate committee identifying the skills. I'll just put it, these are the skills that the McRate has identified. There are about 13 skills, but there are much more. Most of you have given many other skills that a lawyer required. Okay. So therefore, now you look at now you look at this. What am I going to ask you? The next question is, if these are the skills that is required for a lawyer, how many of these skills are you learning by any activity that you are having in the law college? So therefore, now you have to list the activities that you are doing in the law college, which can give some of these skills. I'll give you one is seminar method that everybody read. Seminar presentation that gives you communication skills, research skills. Like that, can you identify some of the activities and start typing? Mood court, yes. Client counseling. Youth parliament. Crime scene investigation. Legal aid. Mediation. Trial advocacy, good. Quizzes. Arbitration, competition, okay. Debates, yes. Pro bono. Okay. Group discussions, that I think I have not catch. Case analysis. Okay, so please remember now, as a student, when your teacher asks you to make a presentation, if you come to the class, take a piece of paper, start reading. Because most of us look at seminar presentation for marks, internal assessment. It's not. You get marks as a bonus, I would say. The seminar is for the purpose of improving your language skills, your communication skills, your research skills. Instead, what you do, the topic you put straight away into Google and search Whatever comes, you write. Now, who is losing here? The teacher will tell you 2 times, 3 times, don't copy from internet, read books, articles, try to write, summarize. So therefore, as a student, if you are focusing only on the marks, but not understanding why a teacher has asked you to make a presentation, you are losing that skill. So therefore, when I say clinical legal education, don't ever think that clinical legal education means I have to go to the court and represent the client. No, there are many skills that you could learn in the law college. Yes, I understand. If you are paraphrasing, at least it is improving your language skills and communication skills. But even that is not done by many. So maybe there are different reasons. I have experiences now, particularly after the COVID. Now my students straight away will put that into Google and they present. When I asked freedom of speech and expression, somebody started the First Amendment provided freedom of speech and expression as a fundamental right. I said that is America, not India, which he has no idea because no research. So therefore, of course, this is the activity we have already done. Sorry, I didn't put that. Listing the activities. I just put some of the activities. Most of these things must be done. Seminars, moods. There's one problem with the moot court. Now the moot court has become more drama than the research. And some of the lawyers says moot court is the best example how not to argue in the court. We have reached to that level. The problems that comes are absurd. They are not serious at all. And a lot of mistakes. They don't check jurisdictions. They don't check the law. Everybody want to conduct moot court. Everybody participate in moot court without understanding the purpose. Okay, so every activity, if you are a teacher, suppose you are going to give seminar, ask the student to present a seminar, and the student, why you want seminar? What is the benefit the student is going to get apart from the marks? Then tell that these are the skills that we are looking for you to make the seminars. Maybe some students at least would do. Debates, legal literacy programs, presentations, cultural activities, very important. How to work with a team, because you can choose only friends in your life. Your families now you cannot choose, your colleagues you cannot choose, your opponents you cannot choose. So how do you have that team building? Mock trials, competitions, research papers, clinics, legal aid, reflective writing is another example, very good example if you want, as a teachers to avoid this kind of plagiarism, copying. Tell them to write a summary of your class. Or tell them to go to police station, observe a day and just write a page, what they observe. So you can't Google it. Probably they may use ChatGPT, possible. Surveys, simulations, workshops, internships, helping public interest litigations, journal writing. These are all part of these skill learning. Okay. So what are the challenges that we have to implement clinical legal education as a method of teaching? One is we don't have expertise. The teachers don't have expertise. All teachers are not exposed to this kind of teaching. That's one problem. The second one is that the faculty need innovation. You have to think innovative. Think innovative means more work. Therefore, why should I do additional work when there is no any incentive? Other problem is the resources. Sometimes the simulations requires resources. Resources in terms of time, manpower, and also materials, etc. Infrastructural facilities is another problem. I have seen some of the, say for example, in a classroom, if I want to conduct a simulation, some of the classrooms, they have fixed tables. So you cannot move around, you cannot turn around, talk to each other, and you want You want to have more classrooms because the students has to work in groups. You don't have place, those problems. Then 90% of our teachers will feel this sort of syllabus, that the syllabus is hanging on their head. You have to complete the syllabus within 3 months, 4 months. So that's another problem. The faculties have not been trained. The semester system, I'm really critical about semester system. I studied in a yearly pattern. We have only 18 subjects, 6 subjects in a year. So first 3 days, 3 subjects, next 3 days, 3 subjects, and the whole year. So there is a lot of time for us to catch up. Whereas in a semester system, the moment you join, within 3 months, the whole semester gets over, excluding the holidays. And then we have this continuous evaluation. Imagine if you have a continuous evaluations of 3 continuous evaluations for one subject. There are 5 subjects in a semester, 5 into 3, 15. 15 times a student is assessed in the span of 3 months. That means in every month there is 5 times he is assessed, he or she assessed. That pressure on the student is too much. Sometimes the student quality. When I say poor student quality, not that the students are bad. The students are lacking interest. That means that the poor student quality and part-time students is together. That means the students, some of them, they just join for the law college for the sake of degree, not for the purpose of practicing. So they may not show interest. And the most important thing is that no incentive either to the teachers or the student. That means any activity that you are conducting in the class, if you give as a continuous evaluation, then the students take it serious. And for doing that work, it comes under the workload of the teacher, then the teacher would be happy to do it. So these are the problems that we have. So how do we address? You increase clinical courses, mandatory clinical courses, introduce this. I think most of them may be doing this trial advocacies, that civil trial advocacy, criminal trial advocacy, pre-trial preparations like law office management. That means you bring some lawyers and tell them how the law office looks, how the cases are, files are arranged, how they write case diaries, etc. And of course, the legal aid. Now coming to this, for example, when we teach the substantive law, this is where a college like mine, a government, typical government aided college will have a problem. Whereas national law schools, private universities don't have this problem. That is, if one teacher teaches contract, immediately there would be a 1 credit course of drafting the contract. Teach constitutional law as a substantive law, have an additional course of constitutional litigation, filing rates, how do you file rates, how it is drafted, how it is, right from printing the documents to going to the court, filing it, everything, right? A family law. When you teach family law, how is the family law practice? Environmental law with environmental clinic, human rights with human rights clinic. That's what every substantive law, at least the major substantive laws, should have a 1 credit, 2 credit practical courses where the lawyers could able to help you. I will not be able to do because I cannot charge more money. I cannot appoint more teachers, not possible, but most of the private universities, national schools, they have the advantage of experimenting with that. Legal aid clinics, I'm not going into that. I think Professor Patil has already discussed. This is another area where you could do it. There are some special clinics. I don't know whether Professor Patil has talked about it. The consumer clinic in our college is doing an excellent work of dealing the live client cases, because in consumer forums, you need not be a lawyer to represent. Similarly, the RTI commissions, you need not be a lawyer to represent somebody, so you help them. And the last one, which I would focus on, which we are doing right now under, I started this legal compliance clinic under which we have undertaken Project POSH, that is prevention of sexual harassment at workplace. The idea of this clinic is not to find fault with anybody. The idea of the clinic is to strengthen, support them to follow them. So we had a project POSH where first we started with the educational institutions, assessed what is their internal committees constituted, whether that is constituted in accordance with the UGC guidelines and the Act. And then we told them to change the composition to comply with the law. Then we trained those members how to conduct the cases when they receive on sexual harassment. So we completed all higher education. Then we are going to second phase to the high schools, then higher secondaries. Then we are inevitably going to the government and others. So this is one good initiative that the law students can actually do that. Identify some law where they have to comply. Go to the people and tell them that this is the law you comply with. Most of them don't know. It is not that they don't want to come. Similarly, RTI, there is a minimum disclosure norms. So create a situation, a template where the students are trained, they go to an organization, look at the organization under the RTI, whether they fulfill, if they are not fulfilled, not to complain, but to tell them these are the things that you need to comply. So that's a great achievement and great work for the law students to learn how the law to be complied. So this is my last, because he told me to close it at 8 o'clock. So I have another 4 minutes. What do we need? We need exposure. Exposure to the teachers, exposure to the students. The problem is that both the teacher and the students are very comfortable with the classroom because it's a safe environment, right? Whereas when we go to the community or when we go outside the college, that environment, we don't know what challenge it is going to throw. So therefore, we need that exposure, we need that dynamism. And second thing is that the interest, that the students need to be motivated. Create that interest in the students to learn. It's simple. Ask the student to carry a bare act in the classroom. Ask the student to read the law and what he understands or she understands without reading the secondary. That is how you develop your own thing. That's very important. The commitment. The teachers should have commitment. Students should have commitment, dedication. That it takes time for the teachers. It takes more time for the students. I know that you have to submit an article. If you copy paste, it will be finished in a day or two. But if you are going to paraphrase, write, research, takes 15, 20 days. So therefore, the encouragement should be there to the students, not necessarily give only marks, maybe a simple praising the student. What we did, at least I did, is when I'm teaching for the LLM, one of the student has done an excellent, I'm talking about 10 years back, an excellent work on the defections in Goa. Because her dissertation is on anti-defection law. And Goa is kind of a laboratory those days, because being a small number, every 3 months, we used to have a different governor. So this student has done a wonderful study. So I took her to my class on constitutional law in LLB. So that's an incentive for the teacher, for a student, that the teacher is telling the other students that this student has done some great work. I want her to make a presentation in the class and have a discussion. That's a great incentive for the students. So they really get motivated with it. And the another thing is the network, that is learning from others is very important. And probably we could bring some community members to the classroom. Maybe a sarpanch would come and tell how the grassroots panchayat is working in a constitutional learnings. That would be great. Or an NGO who is working for the children's rights can come and teach, come and engage a lecture or have a discussion with that. And somebody asked what is the role of the BCI. Don't look at the BCI. They are not professionally equipped with doing these things. Forget about that. It's not required. You may ask the local bar. You have local bar, they would be much better positioned to help you. Okay, so on the whole, what I'm saying is that clinical legal education is a wonderful thing if we can wholeheartedly do it in the college. For that, both teachers, students, and lawyers, particularly your alumni, take the help of the alumni and comprehensively try to do something. It's always a challenge. You learn by doing. That's why DIY, do it yourself. That is the mantra everywhere. Okay. Thank you.
Um, Thank you so much, sir. I think if the participants have any question, they can drop in the chat box itself.
Problem is, I think they did, but I can't. Yeah, I can see this. Yeah.
Yes, sir.
Yes, that is one comment that the semester system doesn't give you the time to learn and do. I agree. That's why I was a little critical.
Another question, sir. Not all law colleges are very supportive. There are always some issues. How, as a student, we can promote such activities at base level while also coordinating with different institutions?
Yeah, see, I have this problem. I do understand. I'm not saying that there are no such problems. There are some colleges which are not supportive at all. I agree. But as if you are a teacher, if the question was asked by a teacher, my answer would be once you enter into a class, you are the king or a queen. Nobody can tell you how do you teach, how not to teach. Therefore, you can do it. If you are a student, for example, the college is not supportive doesn't mean that you can create your own groups. Talk to the teachers who are having a similar mindset. Have the discussions, not necessarily in the law college. Activity need not be in the law college, it could be in some other place. That's what I'm telling you. When I did my LLM, I learned the constitutional law in a social context from my teacher, Professor Seshaya, he is no more in the tea shops rather than in the class. So he used to call the moment we have some time, I used to go to him, he said, let's go for a tea and sit an hour for a tea and discuss. So therefore, the activities need not be done in the law college.
Another question, sir. Any insight on the budget issue, how to handle? Because we don't have budget resources, so what to do in
Okay,
this?
let me explain. Now let us do this way. For conducting a simulation in a classroom, you don't require budget. Whether it is client counseling, whether it is negotiation, mediation. Say, for example, when I'm teaching contract, I'll just give you a simple example. I teach contract, and that too, I'm teaching contract to the second semester. That means some of the students are still minors. Okay, so we always say A made an offer to sell his house for 10 lakhs and B accepted. It is an agreement and it is a contract. But in reality, it doesn't happen. So I give them a small simulation exercise where two of them are sellers, two of them are buyers. I divide the whole class into 10, 15 groups in my class time, and I'll ask them to buy and sell the house. For that, I don't require any resources except printing in a paper, which I think most of the law colleges provide you a printer. And then you assess and then ask them whether how did they come to a agreement. What did they write there? For example, most of them write agreed for 20 lakhs. Now 20 lakhs, when they are going to pay, how they are going to pay, whether there is an installment, what if they don't pay. So once you start questioning them, did you think about this? Did you think about that? Then they will realize that the contracts are not entered just for the one offer and acceptance. There is Once you agree, then there would be renegotiations. Final content once they write, then only they call. So those kind of things you don't require resources. If you are going to do legal aid, the travel, etc. One method that we did is that we charge the students. We started with 50 rupees fees from each student for the legal aid. And with that money, we used to conduct. And I will tell you now, we are conducting legal aid program, a legal literacy program within the budget of 2 to 3,000. Because most of the places where we conduct is the panchayats. Panchayats have their own buildings, they give you free, or we conduct in a college or a school where they give you the free. Only just some kind of refreshments. And the resource persons travel on their own because they are all my alumni, they have undergone this. So therefore, it doesn't require much money. My experience is more money, your legal aid will die.
Oh, thank you so
And
much,
also,
sir.
and also you could look into the private organizations, NGOs, these Lions Club, Rotaracts. Some of your students would be the members of them, so you can happily tie up with them.
So we have a question here: how to manage financial condition by managing practical knowledge in college?
That's what I'm saying. What is the financial burden that you are looking? Suppose you want to conduct a trial advocacy. What is the cost? There is no cost. See, there are excuses always. When we see, for example, legal aid. When you are saying legal aid, the students has to travel from college to a particular village. Students travel on their own. There is nothing that students can't spend. Uh, I I understand if you want to have a law office. That's not required because we run 25 clinics in places where they give us free of cost, like a school, like a panchayat building, like a temple, in a church, all. And of course, the district legal service authorities has enough money, but not that easy to get from them. And another one is tap from your alumni. Alumni are great resources. They do give. And you don't require too much money. See, I'll tell you, when we are conducting a legal literacy program, we give one samosa and a small a tea that costs you around 10 to 12 rupees per person. If 100 people are there, 100 into 12, 1200 rupees. Maybe a small this thing, that thing, most probably 1500 rupees, 2000 is the maximum money that we spend.
Thank you so much, sir. Thank you so much for an informative session on clinical legal education, so apt and relevant. Now I welcome Dr. Kalpesh Kumar L. Gupta, founder of ProBono India, to deliver the vote of thanks.
So, so thank you very much, Shreya, Harsh, and Puja Lakshmi and Dr. Kaushik Bagchi. So let me tell you, Patil sir and Prasad sir, only one message away. No need to call, sir. There is a program, talk is there in training program, so sir, always available. Like no need to call. Like one message away. And let me tell you, I have listened to sir maybe 6 or 7 times. This maybe 7 times online, offline. And I would say my guru in like clinical legal education. So yesterday I also discussed with sir's UNDP report and experience what they are doing. So, sir, thank you very much on behalf of organizing committee. I would like to thank and grateful to you spending a valuable time, and look forward to see you. I hope the participant and the faculty members, especially, they will be trying to inculcate what they have learned in today's session. So, sir, look forward to see you in future events also. Thank you very much.
Thank you, Kalpesh. It's always pleasure working with you. Thank you very
Yeah,
much.
thank you.
Bye.
Thank you, sir. With this, we conclude this session. Until we meet again tomorrow, thank you and have a wonderful evening.
Thank you, Shreya, Harsh, Puja Lakshmi, Dr. Kaushik Bagchi. Thank you very much, all the participants.